Okay. Good evening, everyone. This is the City of Englewood City Council and Planning Board joint meeting. We are meeting telephonically and virtually via Zoom. Today is July 12th, 2023, and it is, be exact, it is 7:38 in the evening. Could we all please rise for the Pledge of Allegiance? I pledge allegiance
To the flag
of the
of the
United
United
States
States of America
and
and
to
to
the
the
republic
republic
for
which
which
it stands, one nation,
under
under
God,
God,
indivisible, liberty
liberty and justice for
for
all.
all. Thank you. Yancy, will you please read the statement regarding the Open Public Meetings Act?
In accordance with New Jersey law regulating the holding of public meetings, specifically the Open Public Meetings Act, notification.
I'm on a Zoom meeting with the Board of Englewood. I'll call you.
All right, excuse me, could everybody just mute themselves for the moment?
Yancy, can you mute everybody? Or I'm sorry, wait till after the roll call. I apologize.
All right, sorry. Sorry, where was I? Specifically, the Open Public Meetings Act, notification is hereby given that the Englewood City Council and Planning Board will hold a special joint meeting on Wednesday, July 12th, 2023 at 7:30 p.m. via Zoom. The purpose of the meeting is to have an affordable housing presentation. The governing body and planning board may also go into session, discuss items permitted under the Open Public Meetings Act, specifically contract negotiations, litigation matters, and matters within the attorney-client privilege. I think we're not doing that anymore. Members of the public who wish to participate in this meeting may do so by calling or clicking on the link below at 7:30 p.m. Please see the link on the City of Englewood website or by dialing 929-205-6099. The meeting ID for this meeting is 916-7431-8231, and the passcode is 042065. Individuals calling into this number will be able to fully participate in the meeting, including providing public comment. The comments may be submitted by 3 p.m. on the date of the meeting, either through written letter or email, meeting@cityofenglewood.org. All written comments shall be read during the public forum portion of the meeting and shall be subject to the same time limitations for public speaking. Duplicate comments shall be noted for the record and summarized. The agenda for the meeting can be found on the city's website at www.cityofenglewood.org. A separate meeting will be used for the closed session if needed. The City Council and the Planning Board reserve the right to discuss and act upon such public business as may be brought up for consideration to the extent that consideration of such public business is not known at this time. Formal action may or may not be taken. Proper notice having been given, the municipal clerk is directed to statement in the minutes.
Thank you, Yancy. Roll call,
For the
City Council.
Councilman Cobb. Everyone, please unmute so I can hear you. Councilman Cobb. Councilman Cobb. Councilman Cobb. Councilman Cobb.
He was here before.
He was here. Councilman Rosenzweig.
Here.
Councilman Wilson.
Present.
Councilwoman Wasatski.
Present.
Council President Marin.
Here.
Also present is Mayor Michael Wild, City Manager Robert S. Hoffman, City Attorney Levi Cool for Bill Bailey, and we have Kelly Gallo, I believe, from Zach's office.
Okay, we're now going to turn this over to Chairman Anthony David of the Planning Board.
Good evening, everyone. Thank you very much for attending this meeting, this joint board meeting. I'd like to do a roll call, please. Who's take, Mr.
Oksana.
Oksana, could you do a roll call for the planning board, please, ma'am?
Yes, Chairman David.
Here.
Vice Chairman Schaefer. Absent. Mayor Wilds.
Here.
Councilman Wilson.
Present.
Miss Patina Valley.
Here.
Mr. George.
Here.
Ms. Cardone,
Here.
Mr. Lerman. Absent. Mr. Rosenblatt
I'm here.
and Mr. Almonte. Absent, and Ms. Mann.
Here.
And also present, Board Attorney Douglas Byrne.
Here.
Not sure if Chelsea is here from the
She's here.
planning.
Yep, she's here.
Chelsea?
She's here.
Okay, all right, that's it.
Thank you very much, Oksana. I really appreciate
Welcome.
that. Before we get started, I'd like to make a quick statement. This meeting was, we were brought together this evening by Mayor Wiles. And if he would, before we get started, I would appreciate it if he would give some kind of statement or acknowledgement of fact that he called this meeting and what he believes that it's for and what we're trying to accomplish tonight. Mayor Wiles, can you say a few words?
Yeah, I'm
before we
sorry.
start?
Wait,
Mr. David.
wait.
Mr.
Excuse
David,
me,
Mr. Wild, yeah, Mayor Wilds, before we get started, in terms of the process and procedure, I just want to kind of establish where we are and how this is going to move forward. This is a unique circumstance doing a joint meeting. We do have to follow proper procedures and make sure that everyone is given their due course. The way that this is going to proceed tonight, and I do appreciate Mr. David and Mayor Wilds that this is, for lack of a better term, your show. But we do have to follow this proper procedure. So how this is going to move forward this evening is we're going to have the planner, Mr. John Zabo, give a presentation. At that time, all members of the governing body and the planning board will be muted. This avoids any cross communication, any sidebars, any over talk. We'll give every member of the governing body and the planning board the opportunity to be heard, including Mayor Wilds. And we will do that through the procedure that we use for public comment, whereby you raise your hand, you'll be acknowledged by the city clerk, and she will give you opportunity to say and talk and have as much time as you need to speak after the presentation is done. Once that is concluded, we'll then go into public session. Each member of the public will follow the same procedure of raising their hand and will be given 3 minutes. That time limit does not apply to members of the governing body or to the planning board. I just want to be clear that you guys will be given as much time to go through. But before we get into statements about what's going on or how this has come to fruition, I believe it's prudent to allow the purpose of the meeting to come to fruition, which is for the planner to provide his presentation.
You ready to the mayor giving a statement? Is that what you're saying?
It's not a
Yes.
statement. I would just want to greet everybody and thank them for being here. In all truth, this is a joint meeting for us to get to the facts of a very serious issue. It's not the master plan, but it has to be in conformance with our master plan, and we have to make sure that we satisfy all the legal requirements. The legal component and our hands possibly being forced is critical. I'll have plenty of time to speak during the session, but I just want to welcome everybody, and I thank you, Mr. Chairman, and I thank all the residents that are joining us as well, as this is a very serious issue. Not in my backyard is not going to be accepted by the courts, and we have to wrap our hand about what the right thing for Englewood to do is.
Yeah,
Very
thank you, Mayor.
good. With that being said, so you want to take it over, Mr. Cole?
Yeah, Mr. Dave, thank you, and Chairman, thank you. So just one more point of clarification. There will be no closed session following this. We can't do a joint closed session. There's questions about whether or not there's attorney-client confidentiality across the boards, because there is a point where we might be conflicted. There might be opposing views across the two bodies. So if there are any questions as to legal process or procedure, a legal opinion, I ask that you just withhold those questions until you're meeting with your body in your closed session. I know we both have meetings coming up. The governing body is scheduled to meet next Thursday. I'm not sure what the next planning board meeting date is.
The 25th.
The 25th. Okay. And I know that there's also council meeting also scheduled for the 25th. So, all the questions about litigation or process or the impacts of decisions, I do ask all the members of the governing body and the planning board to refrain from asking those in this joint meeting, as those need to be reserved for a closed session where you can ask your counsel in confidentiality the impacts of what you do. Again, I trust that everyone here is for the best interest of the city of Englewood, but there is a potential that there are conflicting opinions and legal perspectives. So we just have to be sensitive to that. I did speak with Mr. Byrne about that. I think he's in agreement with that. Doug, do you have anything that you want to add to that?
No, but I want to ask a forbidden question for a moment. It's an informal, not a formal hearing. Do you intend to swear in Mr. Sabo or just let him talk?
Since this is just a presentation, there's no formal testimony. We're not having a hearing. We're not taking any formal action. I don't believe that's necessary. And again, just to be clear, there is no vote happening tonight. No decision is being made. This is a presentation and a discussion that's going to be had to try and bring as much up from the ground and into the light.
Good, I agree.
All right, and without much further ado, I'm going to turn this over to Mr. Szabo and him to take the floor.
Before you do that, Mr. Almonte joined us, Yancy, on the planning board, if you don't mind putting him in as a panelist.
And Oksana will note that.
Yes, I did.
Thank you, Oksana. And Yancy, in the meantime, would you also mute all members? Except for Mr. Szabo.
All right, 1 second. Mr. Szabo?
Thank you. Thank you for inviting me to make this presentation. For the record, my name is John Szabo. I'm a senior planner with the planning firm of Burgess Associates. Our office is located on 25 Westwood Avenue in Westwood, New Jersey. And I authored the housing plan as a result of what I'm going to discuss with you tonight. And the purpose of the meeting tonight is to basically clarify and illuminate how we got to where we are today. And I'll make a presentation. If I may, I'm going to share my screen. It'll be similar to the presentation that I made to the planning board back in April. But again, it's good to revisit this so that everybody's understanding is on the same level. We may not all agree, but at least the factual information will be presented. So with that, I'd like to share my screen. So Yancy, if you can allow me that, right? I'm still disabled.
I'm going to make you host just to make it quicker. And that way, just remember to make me host later, please.
All right. And can everyone, you can now see my screen? And can everyone hear me?
Yeah, we see a slideshow and we hear
Very
you.
good. Okay. This is again similar to the presentation that I made back in April, but again, for the purposes of tonight's meeting, we'll go through this as presented here. So the question becomes, what is a municipality's affordable housing obligation? And what is the requirement? Every municipality in the state has a fair share obligation. Unless you're designated by statute as an urban aid community, that would include cities like Jersey City, Newark, Camden. They are basically exempt from the requirement. But how do we arrive at the affordable housing obligation? It's based on a calculation of statewide needs, which is then distributed to regions, which is then distributed to individual municipalities within a particular region. But the bigger question is, where does this obligation come from? And it's a constitutional obligation, which is important to understand that this is a New Jersey Supreme Court decision that we must abide by. So there are a series of major Supreme Court decisions that impact affordable housing in the state of New Jersey. The first that started the whole process was Mount Laurel 1. It was decided in 1975, which interestingly enough, we're approaching almost 50 years or a half a century now of affordable housing in the state based upon the Mount Laurel doctrine established by the Supreme Court. And what the court did in Mount Laurel 1 is it determined that every developing municipality has an affordable housing obligation. Now, this left a lot of area for dispute, and it wasn't very clear what the court meant. It was based on the DCA infrastructure map at the time, and so it led to a lot of litigation. So there was a subsequent decision, Mount Laurel 2, where the Supreme Court clarified its Mount Laurel 1 decision, and it determined that every municipality has an obligation, but those in growth areas have a greater obligation than those in non-growth areas. Now, as a result of Mount Laurel 1 and 2, the state legislature passed the Fair Housing Act, which established a process by which municipalities would be provided their obligation numbers. There was an administrative agency known as COA, Council on Affordable Housing, that was created that was going to manage this whole process. And then that was the Fair Housing Act was challenged. Well, in 1986, under the Mount Laurel 3 decision, the Supreme Court affirmed the validity of the Fair Housing Act that was adopted in 1985. So the process that was created that established the COA, Council on Affordable Housing, which established a mechanism for how the obligations were to be determined, and then the procedural requirements of how a municipality was to react in complying with that, with their obligation, was all upheld by the court under Mount Laurel 3. Between 1986 and 2015, there was a process. It was the first and second rounds, and I'll get into the time periods a little later on. But by 2015, we were actually approaching the third round in 1999, and there was a lot of disagreement and a lot of changes that were made to the regulations that led to a lot of litigation. And it got to the point where the Supreme Court determined in Mount Laurel 4 that the Council on Affordable Housing was dysfunctional. It wasn't able to perform its functions under the Fair Housing Act. So the courts were to take over the certification process. So you can see that this is a very court-driven process going back to Mount Laurel 1, which is the New Jersey Supreme Court guiding this whole issue for the state of New Jersey through these various decisions. So what is the Fair Housing Act? Well, as I mentioned, it was adopted in 1985. It was legislative response to the Supreme Court's Mount Laurel decisions. And it was really intended to remove the courts from affordable housing process. It was a process whereby the courts through litigation were determining what the obligations were for the various municipalities. And it was determined that there was a better way to do that. And it was to create the Council on Affordable Housing, which was pretty much delegated the authority to determine the municipal affordable housing obligations, but more importantly, to create a process for implementing the regulations and policies under the Fair Housing Act. Now, before the Fair Housing Act, municipal affordable housing obligations under the Laurel 1 and 2 decisions were determined by lawsuits brought by developers to the court. And what these lawsuits resulted in were what we call builder remedies, where developers were awarded density bonuses in return for building affordable housing units. And a builder remedy is really results in a 20% set aside of affordable units, leaving a developer with 80% of the project as market rate. And the theory there was that the 80% would help fund the 20%. That's that ratio balance that the court determined was appropriate to promote affordable housing in the state of New Jersey. So what's wrong with builder remedy suits? Well, you can't plan for remedies, builder remedy suits. They can come from anywhere. Any developer could determine under a builder remedy suit, my site's suitable, put affordable housing there. So what happens is developers get large increases in density in order to produce affordable housing at an 80-20 ratio of market to affordable units. Well, as an example, you could see the math. In order to produce 20 affordable units, a builder is entitled to build 100 units, just to get to 20. And you could do the math and exponentially expand on that to see where that could lead, where you need to create a lot of market units in order to get that 20% for the affordable. And that's really not a great way to plan for this land use. So it provides no control over location. If a property owner or developer proposed a viable project, it was generally approved by the court, and it could lead to incompatible land uses, high densities, or multi-story buildings and structures in low-density neighborhoods, loss of open space, particularly farmland. And these were extremely difficult and as you well know, costly for municipalities to contest in court. It was a litigious process. And the Fair Housing Act was essentially designed to avoid all of this and to kind of try to create a rational way of going about creating affordable units in the state of New Jersey. And I'm often asked, like, where do the numbers come from? Well, they're derived from US Census data that is then projected into the future. It takes into consideration such factors as population growth, household generation as an example, income, employment, the availability of land, commuter patterns to work. And these are how the regions are developed. So this is a process that's very driven by demographics. And Englewood, for purposes of our discussion, is located in Region 1, which includes Bergen, Hudson, and Passaic counties. And I'm often asked, well, what's an example? Like, what is affordable? What's considered affordable? And what is considered affordable really depends on the region in which a municipality is located on. But for Region 1, we can see what those numbers look like as of 2022. So the median income, and it's broken down by household size, 1, 2, 3, 4, 5, and so on. And it's all based on what the median is at the time for these various household sizes. Moderate income is 80% of median, and you can see what those numbers look like. For a one-person household, for example, you would qualify as a moderate income unit at $64,764 annual income. Excuse me, I have a very sensitive touchpad. Sorry. Or for a 5-person household, it would be less than 100,000. Low income is considered 50% of the median, which is half, and then obviously, and then very low is considered 30% or a third of the median. And the regulations provide that we must make these units accessible to the various income levels: moderate, low, and very low. And again, this is structured according to time periods. There have been 2 previous affordable housing rounds since the adoption of the Fair Housing Act in 1995 that covered the time between 1987 to 1999. We are now in the 3rd round, which covers the period 1999 going forward to 2025. Now, under this 3rd round, there are 3 components to a municipality's affordable housing obligation. It's broken down into prior round obligation, 1987 to 1999. In other words, what have you done in the prior rounds? It doesn't go away. It's additive. We call rehabilitation or present need. Those are the units that are located within your own community that qualify as substandard and occupied by low and moderate income families, where we call that a rehab need. That's the second number. And then you have prospective need. And prospective need is the new units that are required, projected into the future between 1999 and 2025. And that includes what we call the gap period, which is an interesting phenomenon as a result of another Supreme Court decision that we call Mount Laurel 5, where the court determined that while we were wrangling about the process and going through all this litigation and COA couldn't get their act together, the Supreme Court determined that we were still accruing an obligation, almost like interest on a credit card. And that's gotten added into the obligations for all the municipalities in the state. So under the Mount Laurel 4 decision that I talked about a little earlier that invalidated COA's participation in the process, the Supreme Court created 13 vicinages or courts to hear petitions for certification of municipal housing plans. You literally have to sue yourself as a municipality in a lawsuit that files seeking a determination that you are in compliance, that your plan is in compliance with the Mount Laurel doctrine. And the city filed its declaratory judgment and then engaged with the court-appointed special master and the Fair Housing Center to arrive at a negotiated settlement of the borough's affordable housing plan. And these are 2 extremely important players in the process. So I wanted to just spend a minute to talk about their roles. Who is the court special master and the Fair Share Housing Center? Well, the court special master, generally a planner, could be an attorney, but mostly planner, is someone appointed by the court to assist the court in reviewing housing plans. And the Fair Share Housing Center is an affordable housing advocacy group that has been granted special status by the New Jersey Supreme Court to intervene in affordable housing matters. Both provide important input and recommendations to the court in evaluating whether to approve municipal affordable housing plans. Sorry. I want to talk a little bit more about the Fair Share Housing Center for a moment. The Fair Share Housing Center is the primary affordable housing advocacy group in the state. We all know about them. If you're involved in a municipal level, you know who they are. They successfully challenged and had COA's third round growth share rules validated by the New Jersey Supreme Court. And that got the ball rolling to where we are today with the invalidation of COA. They were granted special status to review all affordable housing plans submitted to the court, and I assure you they do. Any filing with any declaratory judgment filing with a vicinage or a court specially appointed to hear these matters, they get a notice and then they get involved. They can challenge and demand a trial if they feel a municipal plan does not go far enough to further affordable housing, and they hold a major influence with the courts in deciding affordable housing obligations. So they're an entity that you have to take notice of and you have to work with. So what is the obligation? And I'm going to walk everyone through what the numbers are. The obligation, the rehabilitation of present need obligation is 380 units within the city. Though remember, that's the units that are already substandard and occupied by low and moderate income families within your own community. There's the prior round 1 and 2 obligation, which is 152 units. And then there's the prospective need that I talked about earlier, including the gap between 1999 and 2025, which is 819 units. Now, the good news is that the city does not have a prior round obligation. You had a prior round obligation of 152 units, and the plan details, and the court accepted that we've satisfied our prior round, and we list the cases and the sites that allow us to take those credits. And that's a good thing, because if we hadn't have done that, prior round would have been added to your prospective need and made that number grow substantially, but you've taken care of that. So, and I think that the court was made aware that the city of Englewood has a proud history of promoting affordable housing within its community. So then that leaves us with our rehab obligation, or present need of 380 units. And the city was permitted to conduct a structural condition survey to determine what its rehab obligation was. It was established through negotiations and statistics with the Fair Share Housing Center. That's 380. The city did conduct its survey. At the time we were doing the plan and presenting this to the planning board, it was still a work in progress. The actual survey, which encompassed the entire city, came up with pretty much the same number. So there was no advantage necessarily to conducting it other than to try to lower the obligation, but it didn't result that way because the numbers were almost equivalent. But the city is entitled to a rehab credit of 152 units in recognition of the rehab that's taking place at the Tibbs Senior Center located at West Street, 111 West Street, which reduces the obligation to 228 units. So what do we do with those? Well, the city is going to establish a housing rehab program. In fact, the council will be considering a manual to guide that program to address its obligation for rehab. And it'll partner with various housing agencies, including participating in the Bergen County Housing Rehabilitation Program. So we've covered that. That's going to be handled through that program. So the prospective need is of 819 units. And this is the affordable housing obligation that is projected into June 30th, 2025. So it's important to understand that we recognize that the city of Englewood has little to no vacant land. So we are the city is what's called a vacant land adjustment community, which breaks down that obligation of 819 units into two components. One that we call realistic development potential, RDP, and then there's the unmet need. Now, how do we determine the realistic development potential? Well, the city is entitled to a credit of 95 units from a 2015 court judgment of compliance and reclose for these projects that are listed here. That was as a result of a prior litigation and builder's remedy suit that was then kind of it evolved into a judgment of compliance and repose, almost as if you filed a declaratory judgment action. And so you were given a judgment of compliance and repose that expired. And that's why we're here today to now finish off the rest of the third round time period. But you received a credit of 95 units. As a result of your vacant land adjustment, we looked at every parcel in the city, parcel-based, and we looked at it was a parcel-based mapping, and we overlaid all of that with environmental features that we're allowed to use to exclude acreage, not properties per se, but acreage out of the calculation for determining what may be viable as part of a realistic development potential. And you don't have much vacant land. So our analysis of the city's vacant land was a determination that you had 23 units that could come out of the vacant land that you did have that was not encumbered by steep slopes, floodplain, and other kinds of environmental limitations, historic properties, et cetera. When you do a calculation for realistic development potential, you have to look at what is likely to occur. And the way you determine that is you look at projects that are either approved, are going to be approved, that the city is aware of, agreements that have been entered into that indicate that there's going to be residential development, that those kinds of scenarios are taken into consideration. And what was determined was that the city's realistic development potential, units that are likely to be built, would be 76. But if you remember, there's a very high obligation of 819 units. So what happens to the rest of those? But let's talk about how we satisfy RDP, because that's an affirmative requirement. You have to provide zoning or project approvals for those projects that are part of your RDP. And we've done that. We satisfy our RDP with these various projects, the RA Hotel pad site, Bristol Assisted Living, 202 First Street, Vivian, and we get rental bonuses, which are calculated as a percentage of your rental obligation, which is 25%. So that comes out to 19. Now, these asterisks indicate that there's an adjustment because senior development is capped at 25%. So you can't get credit beyond a certain number of senior units, but we maximize what we were entitled to under that. So that leaves us with a tremendous unmet need. And when you do a vacant land an assessment and adjustment, it's kind of a misnomer because people think that, well, we did a vacant land adjustment, we only have these many units we can support, plus our RDP, the rest should go away. The obligation never goes away. What happens is you treat it a little differently. The mechanisms that you employ to address unmet need is different than RDP. Right, the realistic development potential. The realistic development potential I talked about is affirmative. You've got to address it. It's got to happen. It should happen. It's likely to happen. The remaining balance that's known as unmet need is basically what we like to say is aspirational. We are creating opportunities for this, but you're not obligated. There's a big difference between creating the opportunity and then incurring an obligation. That doesn't happen with unmet need. So what happens is the RDP is subtracted, and this is, forgive me, it is called, we call it jokingly COA math. And I don't want to lose anybody with it. Just understand that we subtract the RDP from the total prospective obligation of 819, but then we further reduce that number by the credits that we received on the prior judgment of compliance and repose, which left us with 724, and we further adjusted that by subtracting out the 76 units, and then the 8-unit credit from the Bristol Senior Assisted Living. So the final unmet need after all those machinations of math comes out to 640 units, which seems, it's a tremendous number of units for a city that has very little vacant land, but that's the obligation that we're working with. So what are the components of meeting or addressing unmet need? Well, the first approach is to create overlay zones, permitting inclusionary multifamily residential development, which requires a 20% set aside for affordable units pursuant to the settlement agreement that was approved by the court and fair share. And it designates, these areas are designated by block and lot, and they each got a separate density based upon where they were located. So where you were located, the highest densities are in areas that are already experiencing high density development. There are areas near your downtown, the Engle Street corridor, but those areas that abutted the single family zones got lesser, smaller densities, consistent with what you already permit under your current zoning under the RMA and RMB zones, which allows a density of 12 units to the acre. We haggled with fair share about that. They objected to the 12, but they accepted 15, which was not a significant impact. So those areas are going to get a density of 15. Sorry again. And there's a mapping of where those areas are. And it was important to the city. I was, directed to make sure that all the wards are involved in providing affordable housing. And the current plan, as presented in the housing element fair share plan and in the fair share settlement agreement that was approved by the court, reflects that. There's a second component to addressing unmet need. The city has agreed to create a program to assist nonprofit affordable housing organizations with the goal of providing 25 additional homes for families by July 1, 2025. This would be a 100% affordable housing program. The city will fund the program in part through its spending plan and in part through the cooperation in obtaining other public subsidies. Where does that money come from and what's the spending plan? The city already collects, it has over $1 million in what's called the Affordable Housing Trust Fund. And that money is dedicated and it can only be used for affordable housing development. And the monies are obtained by charging developers and by charging building permit fees to anybody that's building. And therefore, it's not a budgetary line item that the taxpayers pay for. The city is obligated to hold an annual meeting in which local and regional nonprofits are invited to participate in sharing ideas and making proposals. It's almost like an RFP. Let's get together and decide how we can best create these 25 100% unit affordable housing apartments. But it's a very important point that we insisted on with the fair share in the court, and we prevailed, was that other than its Affordable Housing Trust Fund, the city is under no financial obligation to fund the development of 25 units. In other words, if the city makes a good faith effort to get the parties together and the whole thing falls apart because of funding or whatever, the city doesn't have to build these 25 units. Now, typically, when you include a 100% affordable housing project in your housing plan, if it's part of the settlement agreement, the city would be obligated to build those units if it were unable to find a developer to do it for you. And that is a tremendous cost. I had one community with a 100% affordable housing development that ran into the millions, and they were having difficulty finding a nonprofit organization to do it. And then eventually they succeeded, but not without sweating for a year or so, because they were looking at a tremendous obligation financially. And they would have had to bond for that, which would have been paid for through taxpayers. So in this instance, we were well aware of that scenario, and we were not going to accede to allowing the city to be obligated. But you need to make a good faith effort, which the city will undertake. And then the final component for addressing unmet need was the city will amend its mandatory set-aside ordinance to require a 20% set-aside for affordable units for all multifamily residential development of 5 or more units. You currently have a mandatory set-aside ordinance. It was implemented as a result of the prior litigation under the Mount Laurel Doctrine. And so this was already done, but it was at a 15% set-aside. And now what's happening is Fair Share Housing Centers insisting on a 20% set aside. So they're demanding that the ordinance will require that any developer that comes in for development of any more than 5 or more units would have to provide a 20% set aside. Now, what I would like to just leave you with some final thoughts, if I may. All municipalities have, that are not an urban aid community, have this obligation. So you're not alone. Many, many towns throughout the state of New Jersey is struggling with this issue. The city is a fully developed community. It has little to no vacant land. So the logical approach was to conduct a vacant land assessment, and which permits the city to apply different mechanisms to its obligation. However, given the lack of land, as I mentioned before, you have limited options to try to meet this tremendous obligation that was imposed on the city. The city has formally entered into a settlement agreement with Fair Share Housing Center, which has been approved by the court. So the housing plan reflects the requirements of that agreement. There can be no changes to the housing plan without returning to the court and without Fair Share Housing Center's agreement. But the danger of that and the concern there is if you try to do that now, this late in the process, two things could happen. One, it opens the door for developers to then intervene because you've reopened the process, which is something that I think would be not in the interest of the city. And so that has to be considered. And you might anger the court. The court was very impatient to get this settled and literally push this process. And the other concern is that the court may react and say, no, we're not doing this. I'll pull your immunity. That's a real danger. Will it happen? Do you want to take that risk? That's the policy question. If you lose your immunity, then that opens the door. You lose all control. You will lose all control over your town because then anyone can file a builder's remedy suit. Right now, you're immune. The court has extended your immunity to the compliance date back in August. And we're processing all the required documents so that we can then get a judgment of compliance or repose, which would then extend that immunity all the way through June, the end of June 2025. So it's important to understand that. It's a very complicated process. It took months and months and months, years to get to where we are now. And to upset the apple cart at this point might have unintended and consequences to the city that may not be in your best interest. How did we do the overlay zones? The overlay zones were determined based on your current zoning and land use patterns. So what we tried to do is we matched up the overlay zone where there are already existing multifamily developments or bordering multifamily developments, and they reflect the densities that were surrounding those areas. And the purpose of that was to maintain compatibility in land use. We weren't looking to disrupt patterns of development. We were looking to provide opportunities for affordable housing development. But with the overlay zones, it's very important that they do not impact current zoning or property rights. The property owners can continue to enjoy their property as it's currently used. There's no obligation on the part of a property owner or the city, for that matter, to develop properties that are designated for affordable housing. The private market would have to pursue properties, acquire them, in most cases, acquire multiple parcels, and there's no obligation on the part of any current property owner to compel them to sell. Therefore, and this is the point I want to leave you with, the overlay zones create an opportunity, but not an obligation. And that's why the distinction is so important between RDP and unmet need, because you can't do that with your realistic development potential, but you can do that with unmet need. If it happens, it happens. If it doesn't, we deal with it in the fourth round. Remember, going back to Mount Laurel decisions that I talked about earlier, you cannot use zoning as a mechanism to exclude certain housing types that then impact low and moderate income families. And that's what towns were doing. So you create the opportunity, but the city doesn't have to build 819 units or whatever the number came down to as a result of our calculations. And I think that's the critical point, I think, that I wanted to make for everyone and when they look at the plan. I understand that there's an issue concerning flooding. The plan does not put the city in further risk of flooding. First of all, the sites are already developed. I mean, we didn't take vacant virgin land and say, let's put 10,000 units here. We took areas that the city's already developed. A very small percentage of the areas impacted by floodplain. When you look at the acreage, for example, and I could just throw numbers out. If you look at the total overlay acreage, you have 154 acres that are zoned overlay, either overlay 1, 2, 3. Only 6.6% of that is impacted or has an exposure to floodplain risk. And we're not talking entire properties necessarily, but edges, parts. It's a very small percentage. And so overall, you're talking 4.29% is exposed or has some exposure to flooding. So it's a very small percentage. And the city suffers, part of the stormwater management issues that you have and the flooding issues you have has to do with your aging infrastructure. And that contributes to stormwater issues after major storms, flooding and the like. And keep in mind that as developers come in and they want to build new housing, that redevelopment will require that the entire infrastructure system that they are responsible for that's connected to their property has to be upgraded to current standard. And right now, the state of New Jersey has one of the toughest stormwater management and flood regulations in the country. And they're being updated again, going back. I think there are new regulations coming out as of next week. So it's important to understand that, and these improvements to your infrastructure is not at the taxpayer's expense. It's at the expense of the developer who is obligated to provide for the proper management of stormwater. And then finally, and then this is another point that I think is important. The jurisdiction for flooding and flood development is entirely under the jurisdiction of the NJDEP. You know, the city doesn't issue floodplain permits, the DEP does. And they have their own regulations that you have to satisfy, and they will not issue those permits unless you meet the state regs. But the city of Englewood does not have jurisdiction over that. So ultimately, there's another agency that will monitor and make sure that any development that occurs there will meet all the floodplain regulations that they have generated as a result of their obligation as an agency to protect the environment. So those are just, you know, some of my final thoughts on all of this, and I will be happy to take any questions, comments. But that's how we got where we are.
John, can you make me host again, please?
Sure. And
Buttons by my name.
where do I find you? Oh, over here.
By my name, 3 little buttons, make host.
Yes, I see you. Oh, there you are. You're hiding. Okay. Make host. Oh, that would be easy. Change host. You got it.
Yeah, so I apologize, everyone. I also should have introduced Kelly Gallo, who is with us this evening. Kelly is one of our affordable housing attorneys. And one thing I do want to kind of segue to her and ask her kind of in more of a procedural question is what the planning board's role is, and Doug as well, to kind of chime in and kind of give an overview and not a litigation opinion, but just a status of where we are in terms of what is happening procedurally and how this has to play forward, because I think that's important for everyone on this call to understand how this process works forward.
You want me
Hi, Doug, if you want to go first, that's fine.
Well, I think briefly, just to put into context, the planning board has 2 statutory roles here. One is to review and comment on any land use ordinances that the council promulgates. There's a referral mechanism in the municipal land use law. And, we comment on those ordinances. And as part of that comment, we evaluate whether the ordinance is consistent with the master plan. And so that was particularly tweaked here when with regard to the overlay zones that John just spoke about are really not consistent. And it was difficult for the planning board to say that the ordinance was consistent with the master plan, when in fact, the master plan includes the zoning scheme for different areas in the city. So when we talk about an overlay zone and more intense density, for example, that clashes with the descriptions in the master plan housing element, that's how the planning board is directly involved with these ordinances. So that's why I think the planning board requested through the mayor to interact and interface with the council directly on that point.
Yeah,
Kelly, with that?
And the master
Yeah, sorry.
plan is also, they also, the planning board's role is also to adopt the housing element fair share plan as well, correct, Mr. Byrne?
Correct.
That's also a role.
Right.
Yeah, and as Doug mentioned, the determination has yet to be voted upon. That is, Doug, to be correct, that's this next meeting on the 25th, that the planning board will make that determination, correct?
Yes. That's right.
Okay. And Kelly?
I was gonna say pretty much the same thing that Doug said. There's two roles. One is for the ordinances to determine whether they are not inconsistent with the master plan. And then also to adopt the housing element and fair share plan, which would then be endorsed by the city council after the adoption by the planning board.
Okay, so
Kelly,
at this time.
comment
Sorry, go,
on
Doug.
the litigation. Sorry, Levi, but I thought that because I know Ed is integrally involved with the what's going on in court, we might want to just do a brief description of what the status of that is with Judge Farrington.
The status is that the settlement agreement has been approved at a fairness hearing. And the city now has to comply with the terms and conditions of the settlement agreement. They're supposed to do that by August 23rd, I believe, is the date for the compliance hearing to for the court to decide whether or not they've actually complied with all of the conditions of the settlement agreement, which includes adopting the ordinances that we're talking about, adopting the housing element, and then providing some documentation regarding existing affordable housing units. Those are the main components of demonstrating compliance.
Thank you, Kelly. Yancy, at this time, would you open this up to questions from the planning board and mayor and council?
Just like we normally would with the general public, if everyone would please raise their hand so we can be placed in queues. There's so many of you. So at the bottom of your screen, there's the raise hand button. Click on that, and you will be placed in queue. The first one we have is Raphael Rosenblatt. Go ahead,
you.
please unmute.
I actually have two questions, but they're brief. The first is, what exactly is a unit? Is it a room? Is it a house? Is it a apartment? What exactly is a unit? And then the other question is, are there different levels of compliance or credits when it comes to rehabilitation versus actual new development? Or is it one-to-one, or how does that work? So
Fair question. Unit is a unit. A unit is considered a housing unit if it's occupied. So it could be an apartment. It could be a senior assisted living bedroom. It depends on the housing type, but it is a housing unit. It could be a townhouse unit, an apartment building. It could be an assisted living bedroom that counts as a unit. It's where it's occupied for habitation by a low and moderate income family.
I guess my question though is, if you build say a 3-bedroom apartment, is that 3 units? Is that 1 unit? Is it, how do you calculate?
A 3-bedroom apartment, that it would be one apartment with 3 bedrooms. It would be 1 unit.
Okay, thank you.
And the regulations require that you have a distribution of 1, 2, and 3-bedroom units.
Okay, thank you. And then just the other question about the credits for rehab versus new development.
Credits, the rehab credits are 1 for 1, and they only apply to your present need rehab obligation, not towards your redevelopment or your prospective need. It's a separate category, which is why we have 3 components in the plan. You do get credits, affordable housing credits for rental, because the regulations encourage rental projects. And you get up to a 25% of your rental obligation credit for every rental unit that you approve. in your plan. And that's
Thank you.
what the credits were in that I illustrated.
Thank you.
You're welcome.
Next person with their hand raised is Mayor Wilds.
I think, John, you did a fine job in explaining this, but I'm sufficiently confused between the 819 and the 640. The unmet needs of 640 and the 819 that are needed. Are we falling between the difference there? What's the story?
Yeah, it's COA math. Let me walk you through that calculation. It's a little confusing because you have a credit from a prior legal decision that can get applied to your obligation going forward to 2025. So you have a prospective need of 819 units. You have a credit of 95 units from prior litigation and judgment of compliance were proposed. That results in 724 unit obligation. We adjust that by taking out, because we're dealing with your total. We take out the RDP, 76 gets subtracted from that because that is what's expected to occur as a result of the plan. That's your RDP, realistic development potential. And that ends up 648 units. That's your unmet need, but you get further credits. You get an 8-unit credit from the Bristol Senior Assisted Living project because that's a senior project. You were entitled to 8 units of credit there. So that 648 goes down to 640. That would be slide 16 of my presentation if you go back on the documents that have been submitted.
So
I apologize for the confusion, but it's
that's okay.
We call it COA math.
I was confused what the final number was, but so, this is all evolving out of being compelled by a litigant to make very prompt decisions. And it appeared very rushed to the planning board when they had to opine on this. It also seems, and I have in front of me here, the 2014 third round housing fair share City of Englewood 2014 revision. Our current master plan, I don't think addresses flooding. And we're supposed to adopt something that would agree to a plan of 640 units when our master plan is now dated and we need to do a new master plan to include the flooding and the experience of what we had in recent years. And it's time anyway. And my question to you is, how is this still not rushed, and how, and not to offend any of the professionals here. I believe fundamentally that Englewood, for 6 generations, 6 decades, has been overly generous when it came to low and moderate income. And I can tell you, and everybody drives by, and many people on this session live in these facilities. Are we to assume that we just throw in the towel because we're being pushed around by a judge? The judge in the Alpine case, where the mayor and the council are pushing back very strongly, seems to have a different politic about this. Have we exhausted all of our remedies?
That's a fair question, Mayor. And I unfortunately, what's happened, if you remember the slide, we had the Fair Housing Act enacted in '85. And it was upheld, and it created COA. And there was an organized process to this whole thing. Numbers were generated through the Rutgers University. They were calculated. They were distributed to the municipalities. Everything was transparent. It was out there, published according to the 90-day, procedural act. Everybody knew what was coming, and then the towns went about deciding whether they wanted to participate or not. Because remember, you didn't have to get a judgment from COA that you were compliant. It was a voluntary thing, but the advantage of it was you would get protection from builder remedy suits, which nobody wants. What happened when the court invalidated COA and said, you can't do this anymore. We don't want you involved. You're dysfunctional. You're undermining the purposes of the Fair Housing Act and the Constitution while you're doing it. It became a legal process. The third round is entirely driven as a legal process. Towns have to file actions of declaratory judgment actions against themselves to get a determination from the vicinages, these courts that were appointed specifically to deal with this issue. What that does is it changes the dynamic into a litigation, which then sends it through a process where you can't negotiate and argue your case against yourself publicly. In most cases, you've got to deal with fair share. So it becomes a very convoluted, very, very difficult process, one that I completely
John,
disagree with. So that's how we got here.
I get it, and that's fair, and that's an excellent answer. But here's the problem. When we're put into this litigation motif for experience, and the governing body, the city council and myself, then have to opine in private, and it's all under the umbrella of litigation and subject to the cone of silence, as it were. We're not being transparent then to the public about this overlay. I was assured, thankfully now, that we would have 3 public hearings about transparency about this process, and that the public would be able to be given an opportunity to opine. So a 2-part question for you. We have to make sure that whoever decided what streets and what areas is made public, so the public can, like in a casino, check both sides of their hands to make sure there's nothing unclean, because there are developers that will profit from this in some fashion. And we have to fundamentally see if there's a way out of this thing. Could we buy Evo? Can the city go and buy a certain amount of properties and just have affordable housing and be done with this and not scare people with overlay zones and opportunities and another generation? Evo is a development before my time as mayor in the last administration that got approved down by the monument. A lot of our residents had to leave 111 West Street, and they're being housed there temporarily now. But I'm saying, if we go out and buy 640 units as a city, don't we control this better than creating a overlay zone that may be less than transparent and we don't know the consequences in the future?
I think it's a fair question, Mayor. What I would respond to that is you're not obligated to build 648 units or
You have
640.
to create the opportunities.
Correct. You may not, and the reality is that you may not even get a third of that. You may not even get a tenth of it. We don't know.
What if
You have to
somebody
create
comes in and
something.
says, I'm going to do 4,000 units in the city of Englewood? Somebody showed up at our microphone yesterday.
Mhm.
And what if somebody comes and does that? Can they
Mayor,
do that?
No,
Mayor, if I can jump in, John, as well.
Oh, sure. Yeah, go ahead.
yeah,
I had an answer for that.
Yeah, I think it's probably going to be the same answer as what that would require is buying every overlay zone and buying out every property owner, including the city of Englewood, and including everything that's overlaid would create that impact. It's not realistic. In terms
So it's
of
not realistic. It's not realistic for the city to buy its COA responsibility.
no, I'm sorry. I'm speaking to the fact of having a developer come in and buy enough property to put 4,000 units in. You're talking about overlay zones that are, as John mentioned, these are established areas. These are places that have underlying zoning that are built out. We don't have much vacant land in Englewood. It's what it is. So there's not a farm that they can turn around and say, well, that's not gonna be a farm anymore. That's gonna be a 5,000 unit development has happened up in northern New Jersey.
But what if the city, for example, in a very sophisticated way, went and bought the Actors Fund home? Now we have how many units? Were they taken into account, John, by the way, in the factoring? The nursing home, and the assisted living of the Actors Fund home?
No, I don't believe they were.
Why, it's
So,
predated.
yeah, the age of it and it has to have controls on it. There's certain requirements in order to count a unit as a affordable housing unit towards your obligation. But just to piggyback a thought that Mr. Cool had said, the housing element and fair share plan has been adopted officially by the planning board, and they have a resolution that they're working on that they will be adopting. Anybody coming in outside of that plan, it's up to the city to determine. You have the freedom to just say, oh, that's a great idea. That's not a great idea. You're not obligated to do anything beyond what you've agreed to in your fair share settlement and with your housing plan. So if somebody came in with a crazy idea, I'm going to put 10,000 units on this 50 by 100 foot lot, you're not obligated to do it. That's the protection that this gives you. And you reduce the risk of somebody doing that to you by getting that the judgment of compliance reposed. So, because you can plan, you actually have in these overlay zones, you know, for example, what areas you designated, you know what the densities are going to be. And when you review the overlay zoning that was created, it concludes all kinds of requirements for open space, landscaping, lighting, architectural design standards. You know, you just don't come in and slap a box, and it's in areas that you're planning for. What somebody cannot do is come in with a plan outside of come up with a development proposal outside of the scope of your approved plan and force you to adopt it. In fact, there's language in the settlement agreement that says, once you do this, you're under, even with a mandatory set-aside ordinance, which is a catch-all umbrella for anything that might come in outside of the plan, you're not obligated to rezone, grant use variances, or any kind of approvals if you feel that it's not appropriate. So that's the shotgun that's taken away from your head that you can control better with this plan. Now, to your question, Mayor, if somebody comes in with a proposal that says, I can build 1,000 units and it makes sense, you can do it. There's no, you're not constrained from considering affordable housing projects that are viable in the infinite wisdom of the city, and said, this is a great project, this works. You'll get credit for that. Keep in mind, we have to take care of the third round. This fourth round's coming. It's right around the corner, 2025.
I can't imagine, John, I can't imagine that the Actors Fund Home, and I appreciate your professionalism here, does not get any credit because they newly rehabilitated a portion of their property, much to the chagrin of residents.
I'm not aware. I'd have to look at the deed restrictions on there. There are very specific requirements under the co-regulations that would qualify a unit. In fact, we're going through the process now of qualifying units so we can get the credits that the city is entitled to.
I just don't want to be rushed, not as a mayor, not as a planning board mayor.
Nobody does.
And finally, I don't want to take the microphone longer. I do have the authority ultimately to veto an ordinance, and the governing body would then have to override my veto if I'm not pleased with the pace of this thing. My main concern is transparency. I want the community to know who selected the overlay zones, why they were selected, so that they understand, again, both sides of the hands being shown here at some point, John, in one of these public hearings, if possible.
With regard to, I'm sorry, John, just with regard to transparency, I did want to note that there's a special notice requirement. So every property that's within the overlay zones and within every property owner within 200 feet of the overlay zone is going to receive notice of the public hearing on that ordinance, and will be given
But why
the
were they
opportunity.
selected? Kelly, why were they selected?
That John has to speak to. But I'm saying that's an opportunity.
Who
That
selected
hearing,
it and why?
that hearing would be a good opportunity to address those zones.
Two comments to that, Mayor. Those zones and overlays were presented to the mayor and council in exec as part of the settlement process, and it had to be done in executive session because it was litigation. There was no other way to do that. And what I offered to the planning board, and it kind of piggybacks on what you were suggesting, Mayor. I mean, what do we do, going forward? And what I suggested is that you're due for a reexamination of your master plan next year. And I offered to the planning board that is the great opportunity to assess where you are as a city, have a public process through all kinds of, and the city has a whole history of charrettes and public participation and all that went into the 2014 plan. I have every expectation that the city would follow that same inclusive process going forward. I would suggest we button this up, protect the city, which would give you the freedom to then go forward and figure out how you want to move into the future. And you could make, you could look at areas and you can expand upon, and you can evaluate the possibilities of other sites, like, for example, the Actors Home, 100% affordable. Just keep in mind, we didn't want to obligate the city to huge expenditures associated with this affordable housing plan. But if that's a decision that the mayor and council wants to make with the planning board, it could be a joint process moving forward.
I have no problem working on a new master plan, conducting hearings in all parts of the city and coming up with something that's more comprehensive or timely, given the flooding and everything. What I am obviously concerned about is I didn't have a vote despite the litigation. I could opine, I can say something, but the mayor of the city doesn't vote on the overlay zones. It's the governing body that made decisions, even though I had the privilege of participating in those sessions. And I don't want to gum up the city's position or interests, but I don't like the pace with which this was heading towards the planning board. I just wanted to state that for the record. Thank you.
Next person with their hand raised is City Manager Bob Hoffman.
Thank you, Yancy. John, would it be possible for us to put the presentation that you just did tonight on our website? So
Yes,
that
yes, and I submitted it to Yancy. Absolutely.
It's already
Okay.
posted, it's already posted actually on the website.
These
Awesome.
are public. These are all public documents.
Awesome. Thank you so much.
That was it?
That was it.
Oh, okay, thank you. Next up is Council President Judy Marin.
Oh, thank you, Yancy. I would just like to restate, because I think it's very important, the fact that any property that is covered by the overlay is under no obligation to do anything or to go along with anything. I think that, I know it was stated, but I'm stating it again. I think it's very important. The other thing is what I would like to be repeated, and I'm not sure whether we have, whether we should have Mr. Szabo repeat it or Levi. I would like you to repeat the implication of what will occur were we not to approve this plan at this time, and remind everybody that what was just said, we have a fourth round coming up. So hopefully, you know, anything that we have left out or we can revise, we could do. I mean, if I'm wrong, please tell me. But as I said, I would like the attorney or Mr. Szabo to comment on that, because I think the builders, whatever it's called, the builder's remedy, I would like you to expand a little on this and explain to us, you know, what would be the ramifications of this occurring.
Yeah, and Judy, thank you for that question. John, I'm gonna give you a little context. I'm gonna ask you to expound on this. Recently, Judge Padovano issued a decision related to Saddle River. Saddle River created an opportunity for development on a municipal site on a site, and they had a developer come in. The planning board was not party to that. And they were able to review and ultimately made a determination whether or not that was an acceptable plan. A builder's remedy lawsuit takes that control out of the municipality and also out of the planning board. Builder's remedy really usurps all of the MLUL. And allowing that to happen really kind of, it forgoes what the municipality, what the council can do and what the planning board can do. And John, if you have any comments on that, I think the case in point that it's something important to look at.
Yeah, and I'm glad, I appreciate you highlighting that. You know, just because we zone it, if it happens, you still get another bite at the apple, which is why the overlay zoning ordinance has all these standards in it that enhance the tools that the planning board has to review an application. And it should, you know, the board can insist that it complies with all of these things that add to that. With a builder remedy, I mean, you talk about process and unfairness and you know, how quickly something can happen. You have no control over. That's why the Fair Housing Act was created in the first place. You know, to protect municipalities and provide a fair process towards meeting an obligation and not being subject to costly litigation that municipalities fairly, I mean, I'll refer to the attorneys that have handled that litigation. Municipalities don't generally win out on those litigations. Remember, the court's answer to the Supreme Court, and the Supreme Court's the one that created the Mount Laurel Doctrine. And so there's a predisposition to say, hey, if I have a developer here that can do it, let him do it. And some judges are more sophisticated in land use than others. So this, Mr. Cool is absolutely right that, we're trying to give the city the maximum amount of control that it can have.
I would just add that with a builder's remedy, your zoning basically would, if you were found to be non-compliant with your constitutional affordable housing obligation, your zoning basically does not apply. A developer comes in and you are, 100 units deficient and they want to build a 500 unit project and put 100 units in, even if it's somewhere, with a density of 30 units to the acre in a 6-acre zone, they can do that because they're providing the affordable housing units. So your zoning basically goes away.
And this isn't hyperbole. This isn't an attempt to frighten you or to it's not a scare tactic. This is what we as professionals have been dealing with for 48 years, almost a half a century. So we're just trying to protect the interests of the city so that we give you the best leverage you can over what can happen and what can be built.
Judy is still muted.
Yeah, I just wanted to, and I thank you for your answers. And this is the great fear I could tell you that I have, falling into this abyss and being caught up in the whole concept of the overlay and how that's going to affect the property owners who do not have to go along with anything. We don't have to do anything on these areas. We've identified them and nothing could happen. As I say, at this stage, this is not the end. We do go into round 4, and you, as somebody mentioned, we're going to be reviewing the master plan, and that should, if there are any changes, might have some effect on what happens in the next rounds. But I can't stress enough the idea of having contractors being able and developers being able to come into our city with absolutely no control over them because we could not agree on this. And I do hope that the residents that are on this call and those that hear it at some point will look this up and check this out. We are being as transparent as we can. This is a very, very serious matter. Thanks.
Yeah, I'm sorry to jump in here. I just want to make everyone aware. We're heading upon 9 o'clock. I do want to allot at least an hour. I know the planning board typically has a cutoff time of 11 p.m. I do want to make sure we allot the last hour to the public at least to give their comments. So just everyone's aware we have about an hour for planning board and governing body to make comments and have discussion tonight, and then open it up to the public.
Planning board's cutoff time is 10:30, not 11.
Is it?
Yes.
Okay. Well, if that's what you want, Chairman, we'll go with 10:30.
That's what we do, sir. We don't do 11. We do 10:30.
I apologize. I miss. I
No
was not
problem.
aware. I thought it was 11.
Everybody understands that.
I'm okay with that. You're not here in opposition here.
Very good, sir. Thank you.
But just again, just to make sure we have enough time for the public, I want to just move forward as quickly as we can.
Next person with their hand up is Mr. Cobb. Mr. Cobb?
Yes. So, I'm very troubled by this back and forth because everybody's like the house is on fire here. And the people who sat on the governing body, and Mr. Zabel, what I'd like for you to do somehow, some fashion between you and Mr. Cool is develop a timeline when we engaged you to guide us on, the pros and cons and what we had to do, because this just didn't happen yesterday.
Right.
And that's what's troubling to me. Transparency is at the utmost, I believe, when we had this council, but this has not been slow. This has not been rammed down our throat. We've had a process in place. We followed the process. We've gotten the guidance. We've done everything I believe, in accordance to what we should have done. And if people are concerned about transparency, then I would say that then they should have been engaged from the beginning in realizing how important this is. Because right now to say it's not fair, whether it's fair or not, it's about doing the right thing for the city of Englewood. And I'm going to tell you, I knew this was going to happen, but now we are here. But we got to call balls and strikes now for this and understanding what's going to happen and what's at stake. But this is one of these things that I take issue when they're saying that it wasn't transparent or it appears not to be transparent and all this kind of stuff. Nah, that's not what it is. We have to come up with a resolution, how we're going to present, how we're going to move forward on this and be honest with it. And this is what happens when everybody's not tuned in and realizing how important it is and understanding this process and understanding that Mr. Zabel's been with us, providing us guidance, Bill Bailey, Levi Cool, and all of them. And we've been talking for this. Levi, John, how long have you been with us? How long have we been paying you to provide us guidance?
Oh, since January or so, maybe before that. I don't have an exact timeline, but
Right, but it's been a long time, and
it's been months.
Right. It's been months and months.
For context, the settlement agreement was settled in May 21st of this year, and then there was all these discussions prior to that, and presentations and discussions with the court and the council prior to that.
Right.
Yeah. There were
So
closed session meetings going back quite a while.
That's exactly right, and that's exactly my point. And even so, to the point that last night at the council meeting, I asked that we have a special council meeting after this meeting so we could have that one topic on it and explain to the public exactly what is going on. Because there have been a lot of people doing a lot of work in this area and on that. And I guess we need to explain that, but I'm not going to be a party to like, this is a fire drill and this is what's happening. We've been talking about this ad nauseum. We've had ordinances that we've drafted for affordable housing. Levi, am I correct? We did that. We've been having this conversation for a very long time. So I think that, instead of spending time going back and forth, we should say, how are we going to present that? Is this what we got? And to Council President Marion saying, listen, let's get ready for the next round. And the things that we think we can do, we can do. Let's talk about the master plan in the future and work on things like that. So we don't have whatever people think that was not being fair. But, and again, as I had last night, had people explain what is affordable housing and what does it mean? Because I think that all of this ties itself together. And John gave us the calculations and we went over those calculations a ton of time. Right, John? If I'm not mistaken.
No, that's correct.
We
beat
beat that thing up a number of times. So, okay, now I guess we have to put something out and so everybody can process it and move on to the next step in this process. But again, as somebody who has a vote, I think we've tackled a lot of these issues here. And, I think that I don't want to waste anybody's time, but I'm saying collectively, we need to understand what this is all about. And for those of us who've been at the table, we've touched these issues time and time again with John, with Levi, with Bill Bailey, and with Ed Buzak. So we know where this is at. Now, how important it is to each one of us, that's a whole nother story. And I'll leave that to the individuals themselves. Thank you.
Next is Councilman Rosenzweig.
Hi, thank you. And thank you, John, for a really fantastic presentation. So to just, follow up with some of the other excellent questions that have been asked, when does the public get to, give their input on this process?
Well, because of the nature of the third round and the litigation, the public input comes, first of all, there's a public hearing on the adoption of the Housing Element and Fair Share Plan, which is duly noticed. There is a public notice that is done for the fairness hearing that's required on the settlement agreement, because there has to be a determination by court that the settlement agreement is fair and equitable to the interests of low and moderate income families. There's notice given for that. And then, of course, the implementing ordinances, whereby the ordinances are introduced, referred to the planning board, and there's a public hearing on the ordinances that are introduced. That also requires public notice and hearings. So there's opportunity for the public to participate and voice concerns or opinions one way or another.
So the first one of those, I think, happened back in January, if I'm not mistaken, for the hearing.
The fairness hearing occurred, I believe, in April or so. I don't know the exact date. That was noticed.
The order was
No,
January. I would have to
January.
just-
Oh yeah. Okay. Yes. I'm trying to get my time frame.
I'm sorry to
the-
interrupt. Yancy, could you please admit Howard Schaefer, another planning board member, into
He's in.
panelist?
That is hand raised. He's at the top.
Thank you.
Yeah,
Thank
the
you.
public hearing on the housing element and fair share plan was in April of this year. And that was noticed, duly noticed pursuant to the land use law.
So that
And then,
took
of course, the
place in
ordinance.
Judge Farrington's court?
No, the housing element and fair share plan was, public code notice and hearing was done by the planning board for the residents of the community. The notices are published for the fairness hearing through various, the newspapers and to the interested parties that are part of the litigation.
Now, did anyone from the
The
public?
fairness hearing was in front of, I'm sorry to interrupt. You're correct. The fairness hearing that was back several months ago that resulted in the January order was in front of Judge Farrington. So that's correct.
And if I'm not mistaken, I think someone submitted a comment or a challenge to the settlement.
Yes.
When was that submitted?
I can, if you allow me a second, I can pull it up.
Or
But
just
prior to
legally, on
I
or
can give
about?
Yeah, I can give a little context. So this was Care One that tried to intervene in our affordable housing litigation. Up in, I'm not sure exactly the location, but they were trying to put a roughly 400 unit assisted living facility. And John, you might know better than I do exactly the context of that trying to put up there. And what we ended up doing is overlay zoning that at 15 units an acre. And again, John, you know the actual numbers better than I do, but
pull it up.
yeah, it's had an attempt to intervene in our affordable housing litigation, which if they had succeeded, would have produced a much higher density, closer to a builder's remedy lawsuit where they could have pretty much built what they wanted to in the context of providing affordable housing. But John, if you have those numbers.
I do. Just bear with me one moment.
Well, I'm more interested in the date when that happened.
It had to be well over a year ago that they tried to intervene. That litigation has been ongoing for quite a while. It went up to the federal courts. They filed an RLUIPA claim.
Okay.
They tried to,
So just moving on. Now, did any individuals from the community file a complaint or a challenge?
Comments, correct.
And when were
they
those?
responded and posted that, yeah.
When were those comments posted? On or about?
Bear with me and I will tell you in 1 second. Well, it would have been prior to the hearing was on January 10th. And I believe they were required to submit comments 45 days in advance of that. So around that time period.
Okay, so almost 8 months ago, the public really had the opportunity to weigh in on this.
Yeah,
and we had people from the public give comments to Judge Farrington. I don't know how much they were taken into account. So this has been unfortunately, we by law have had to keep some aspects not transparent, but obviously it's been transparent enough that 8 months ago someone did file comments with the court. So let's say someone, doesn't like that their property is included in the overlay zone. Not in my backyard. And it actually is literally in my backyard, just for the record. What chance do they have to say, hey, kick my property out of this zoning? That's not fair to me.
Well, they could appear at the fairness hearing and state that to the court. They could submit comments prior to that January hearing to the court, and they have also the opportunity to be heard literally in front of the court. And they could also, as John mentioned, appear when the housing element and fair share plan presentation went forward in front of the planning board. And they'll be able to appear anytime any of these ordinances are up for second reading.
Okay, thank you. Just a few more questions. I know we're tight on time. So let's say someone that mentions a particular street near a stream or something like that, and is worried about development on that particular street with that's in the overlay zone. So if we don't pass this ordinance and we're exposed to builder's remedy, would that street still be at risk for development under a builder's remedy suit?
Greater risk, I would say.
Yeah.
Okay.
You're almost guaranteeing development at that point. It'll be a free fall. By the way, Care One was looking at over 300 units.
I think it was over 400.
Well, the concept that we were looking at, but the point is, it was a monstrous development.
But more importantly, the point is, these were known discussions in front of the court that people who were interested had the opportunity to comment and present their plans. My last question is, we had a council meeting last night, and the number came up that we were putting in 4,000 additional units into the city. So how can we get to that? I don't know how we got to. Someone the public came up with that number. I assume it's.
Yeah, let me do some math.
I assume it's 160 acres with 25 units per acre, which is about 4,000. Or 154 acres times 26 or something like that.
Yeah, no, it doesn't work that way. Basically, let's use the number. Let's use the unmet need number, for example.
So that's 640.
Right. If you use the 20% set aside and you create the number, remember the builder's remedy calculation. You have to have
so it'd be
100 years to get to it. So you take that number, you exponentially increase it to create that 20%. You get about 3,000 units. But let me please emphasize, you're creating the opportunity, not the obligation, because it's unmet. It's aspirational. Whether that happens or not is not a guarantee that on the city. It will be left to market forces to determine, well, am I going to go and try to promote some kind of development in this particular overlay or not? And again, I have to emphasize, anyone in those overlays, I have a property there. I like it the way it is. I'm not selling, I'm not developing. It's going to stay the way it is. Done. You can't compel anybody to do anything.
John, can you also speak to the planning board's overview as opposed to a builder's remedy? I know we've gone through this already, but I think it's important to, as that number comes up, I think it's a kind of shock number to kind of say it's an overlay zone is not the same as a builder's remedy.
No, because a builder's remedy is a guarantee. If a developer files a builder's remedy suit and he says, I want to put 3,000 units on this property, and again, I'm using really, let's make it more real, 100 units on a 5-acre unit, on a 5-acre tract. And you don't have immunity under this order of compliance proposed, you're going to get those 100 units because that developer is going to show that it's viable. There's going to be no site plan review and there'll be no standards. I've had situations where a judge would remand something and say, all right, let do something to work out the details, but you're going to get that 100 units, whether you like it or not. And so that's the better term would be the exposure the city faces between an overlay and zoning and controlling everything, at least for the time being, through this settlement agreement, housing plan, the ordinances that are being considered, as opposed to losing your immunity and being exposed to, 400 plus units of assisted living where you may not want it, or 300 plus units, because that project went through various iterations that we don't need to get into, and you'd have no control.
Okay, thank you so much for answering my questions.
You're welcome.
Okay, next person that has their hand raised is Chairman David.
All right, I don't have a question, I just have a statement. I wanted to go on record that the planning board only had one opportunity other than tonight to hear any of this information. So even though it was being planned for months and months and months, please don't lump the planning board into the category that we've always known. When Mr. Sable came to us that first night and gave us a presentation, we were asked to vote on it that night, period. And this was the problem that we had no notice. So I just want to make it clear, just for the record, the planning board has not had a great opportunity to review any of this information prior to us hearing from Mr. Sable that particular night. So I just want that to go on record. Okay, go ahead, please proceed.
Next person is, I believe, Vice Chair Howard Schaefer.
Thank you. And part of what I was going to say, thank you, Anthony, was just that. And I need to kind of expand on the idea of the transparency, and I think Judy raised it in terms of how was the decision made to put the properties that were put into the overlay zones into the overlay zone. Like I still have no idea how that was done. And to say that, well, none of the property owners are compelled to go along with this, the reality is those properties are not going to be more valuable to anybody other than a builder looking to build dense housing on those properties. So that's not going to really be a big check on this process. And not only David, as Anthony said, not only weren't we, as the planning board, brought into this process until basically the 12th hour, we were not consulted at all, period. And, I don't know enough to say that I'm upset with the results, because it's possible we could have ended up with the same result regardless, but I am upset with the process. And with the fourth round basically upon us, this cannot happen again. It just can't happen again. Thank you.
Next in queue is Councilman Wilson. Mr. Wilson? Please unmute.
Kevin?
I'm sorry, I didn't hear you. Good evening, everyone. Thank you for the presentation. I appreciate it. And more so, I'm sure that my constituents and the rest of the community that are watching, they appreciate it as well. As you guys have tackled this for months and months and months, I'm sure it wasn't as easy for you guys to digest immediately. So the feeling of the community is that some of this information is new to them and very difficult to digest. Someone spoke of the opportunity for the residents to file complaints. A lot of residents didn't know they had that opportunity. And when we talk about transparency, I don't know if we need to put that on the planning board website, on the city website, and that you have 45 days to file prior to. With people working, taking care of kids, parents, grandfathers, or whatever it may be, it's very difficult for Mr. and Mrs. Public to know that information without it being right out front. Not saying that we want transparent, but it's unfair to say at this particular juncture that Mr. and Mrs. Community had that opportunity. I'm not sure how that was put out there. I would like to know, how did we come to drawing certain lines, whatever line it may be, and whatever percentage, I think the percentage was 4% that was put out, that may be in a flood zone. If something was built and overlay in the flood zone, that's not a big deal. And I got to tell you, people that are coming to our council meeting and complaining at the planning board are saying that they're being flooded. And I'm sure whoever drew those lines, they don't want that same percentage on their property. So all I would like to do is to be mindful and to be totally transparent on these things here that are impacting people for the rest of their lives. I understand we're talking about in 2025, we're coming up with another round. One of the situations is we're talking from, I think it was 1999 to 2025 was the third round. That's a long time. That's a long time. And I'm not taking away any hard work, any long hours and any Zooms or any meetings or working through this during COVID. I commend those who worked on those. But there are questions when someone draws lines and you say it's done in litigation, and if you're representing the city or the planning board or the community, whatever it may be, how often were we afforded that opportunity to see where the new lines were drawn? Thank you.
Councilman Wilson, if I can just kind of chime in there, you know, it is a very delicate balance. As a municipal attorney, there is transparency that you want to provide to the municipality, and there is transparency that you cannot provide to the municipality. As you continue to negotiate with Fair Share Housing Center and your special master, it is part of privileged settlement negotiations. And that is part of litigation and the part of municipal government that will not always flush out. And as soon as it became public and we were able to make it public, we did. And that is 100% apparent with as soon as this was passed through the special meetings, became public. We've had public meetings, we've had public meetings, we've had public meetings. We are continuing to have these public meetings and we are going to continue to have them. And I hope that, you know, that appeases some of that trepidation. You know, I understand it's tough. It is really tough to balance that level.
So are we able to disclose who and how the lines are drawn?
Sure.
And that's what this meeting is.
Yes.
Ultimately. And yeah, we're gonna publish it all. And sorry, John, to jump in, but yeah, we're gonna publish it all. We have put it, I think Yancey, we put it on the website, or are in the process of putting it on the website. And you know, we're engaging tonight, Thursday night, planning board's meeting Thursday night. I think these are opportunities for it stinks that it's this far down the line, but it's when it has to happen. And that's unfortunately the nature of litigation.
So the nature of litigation prohibits us to know tonight who and how the lines were drawn. Is that correct?
No, I'm sorry. That was
okay, because that's what I'm
not
asking.
my representation.
No,
that's what I'm asking.
This is when we're opening it up. This is when we have the opportunity. And yeah, sorry, John, go ahead.
No.
Okay, because I'm not getting the answer.
It's a fair question, Councilman. First of all, we were going through negotiations, very difficult negotiations with Fair Share, the intervener, and the court, and the special master up until the last minute. We were pushing back on a lot of proposals and a lot of ideas, and trying to come up with the best plan to minimize the city's exposure to what we would think would be outrageous densities of development. And then the judge decided you've got 2 weeks. or I'm going to pull your immunity. So, you know, these are the realities of what goes on when we get involved in affordable housing issues. The lines that you're concerned with, I am a licensed professional planner in the state of New Jersey. I have a fiduciary responsibility to this community to come up with a plan recommendation, present to the governing body through this process that we all hate, myself included, to say this is a reasonable solution to an obligation that you have to meet. The lines were drawn in consideration of a couple of factors, and I do recall explaining these to the council, but I'll get into it again. I looked at existing land use patterns. So we put the highest densities in commercial areas that you're already looking to redevelop, like the first school site. We wanted to put Engle Street has apartments there. Maybe there can be some infill development there, maybe opportunities along that corridor. You have the recreational facility on Engle that could possibly turn at some point. We wanted to control that, because what would happen if a developer came in on a builder's remedy on that 10-acre site, so I want to put 1,000 units here. And you have the sewer capacity, let's say, and it's 10 acres. I mean, it's an outrageous number, but that's what you're exposed to. The lower density areas were looked upon, they had to join other multifamily areas, like they had to abut them. So it was a natural extension of your RMA and RMB zones, which already exist in the neighborhood. So they already a fixture in the community in that area, and we would extend the opportunity possibly on those parcels, but they got the lowest densities. Not inconsistent with those two zones, the RMA and the RMB. And, you know, Fair Share pushed back. They wanted more. We said, no. And we went back and forth. We stuck with 12 units to the acre, which is what you currently permit. They wanted 20. We had to come to some agreement because the court was on our tail saying, now I'm pulling your immunity. So we came up with what I thought was a reasonable proposal. Again, aspirational, it's opportunity, but not an obligation. And that's how those lines were drawn. Now, I'm a planner. I work for communities. Most of my practice at Burgess is for municipalities. That doesn't mean I appreciate the public input. I appreciate the process. I do understand where you're coming from because it offends me as well. But that's the process that was created. And so I have to protect the city, which is my fiduciary responsibility, the best way I can. Is it perfect? Nothing's ever perfect. But this will get you to immunity because the courts accepted it, Fair Share's accepted it. We're going to implement it with your blessing, hopefully. And then we can move forward because I know the tradition of Englewood. You know, I looked at your 2014 plan. I use it all the time when I review use variances. There's a very open process to that. And I expect that the city will follow that going forward. And that can and should happen. And I would welcome it for whoever planner gets involved in that project.
Well, thank you for that answer. I appreciate it. And I'm sure the people that are listening that have not chimed in appreciate it as well. And I'm not saying at any point that there's not a difficult process of making choices.
I know.
And that happens in litigation. But what the problem is that notwithstanding the hard work that the council and the planning did prior to, is that we have a litany of community members complaining, suffering, just barely recovering right now from flooding. So the mere mention of us, the city, possibly being able to build something in a flood zone is going to open up a floodgate of emotions, if you will. And so that makes people very nervous. And then when you put that on top of that, they've missed the opportunity to file a complaint or a writ or go into court. People are upset. People are upset. And then on top of that, you say, okay, we did our best. I'm not saying that you didn't. We did our best. Let's look forward to the next round. Forget about this round because this round has already been voted on in January. All we need to do is vote or open ourselves up to litigation. And it almost seems to to the people that may or may not know, that it's a bullying tactic, not saying by our lawyers, but by the system in general. And it feels to a lot of residents that it's unfair that even if they may not have been involved in the process or just found out about the process, that there's no repercussions for them to adjudicate any decisions or line drawing that we may have had.
Yeah, we definitely hear you, Councilman. I just want to be cognizant of the time, and I know
I got it. I'm done.
Board Member Gordon has her hand raised. You know, I just want to make sure we have enough time for the public before our 10:30 cutoff. Ms. Gordon.
Hi, good evening, and I'll be very brief. First of all, thank you for your presentation. I have a two-part question, and I promise you'll be quick. The first part is, please define what a rental unit is. And the second part is, did we get a credit for the registered rental homes in town already?
We are going through the crediting process now to see the eligibility of the projects that we've listed in the housing plan. I'm not familiar necessarily with that program. I'd have to double check that. A rental unit is what we define as some that's for lease, not owned by the occupant, but otherwise leased or occupied under some kind of a lease.
So would a two-family house give us double the credit?
No, because crediting is a function of your rental obligation total, and it's capped at 25%.
Okay, thank you.
But, you know, that doesn't mean to say, to follow up, that if a two-family resident were to come forward and deed restrict the unit, that unit wouldn't somehow qualify in the next round, but it wouldn't be necessarily for this round.
Okay, thank you.
Depending on when it was done.
Yancy, are there any other hands up for council or planning board members?
No.
Okay, let's open this up to the public. If we have a motion from both boards to open up to the public. Second, and just an aye vote would probably be sufficient.
I move.
Second.
Ms. Mann seconded. I see your hand raised. And all in favor, I guess who's calling the all in favor?
Aye.
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 Opposed? So just for some rules for the general public, again, if you want to make a comment or ask questions at the bottom of the screen, there's a raise hand button. Click on that, and then you will be placed in speak. You'll have 3 minutes each to speak. Once your 3 minutes are done, you will be told that your 3 minutes are up and wrap it up, and then you will just be cut off. All right. So first one with their hand raised, and get my clock. Okay, I will raise my phone when you have 30 seconds left. All right, so first one to speak is Horace Ragbeer. Please unmute yourself.
Good evening.
We can hear you.
Did you hear me now?
Yes.
Okay, Horace Rockbeer, 51 West Hamilton Avenue. I have several questions. I know I only have 3 minutes to ask these questions. But I'm really concerned, we keep talking about density, all right? And I'm looking at the map. Could we have a map that actually, like for separate wards, designating what is going to have affordable income? I know we have to meet whatever state requirements, and we have a short time to do it, but the map is a little hard to understand. And looking at it, it is mostly centralized through Ingle Street. And with that said, when we talk about density, Ingle Street and the area on Pindle and Slocum and Hamilton, which is a complete flood zone, all right, and I don't think it represents 4%. I think it represents a little more than that. The density in 1-4 and 1-3 has changed a whole lot because of immigration. We have one room, 5 people living inside of it. And I don't know if the density you're talking about is the amount of people that are living in a certain area. And why, based on the map itself, why wasn't any of these affordable housing put, let's just say, I don't notice that any was put up the hill, close to Englewood Cliffs, to Leonia, Teaneck, Tenafly, and all the affordable income properties looks like just centralized onto Ingle Street. Is there nowhere else that it could be designated? I mean, I think instead of building big apartment units, the whole Ingle Street has apartment units. Sigma is right across here. The hospital is here, right? So we're looking at the whole aspect of where you propose, Mr. Sabo, that to make these, I think with lines and the way it's drawn, most people cannot come up with a conclusion. We have dotted red lines, we have full red lines, we have black lines. I think we need to do it in like a separate version, like each ward where you want to designate it so we could understand it in layman terms. And I think we need to look at the bigger picture. Yes, if you're showing it in all 4 wards, that's a great idea. People should be able to live in any ward they want to. But I think centralizing it is going to increase the density of traffic, and everything that comes down is going to create a bigger issue. So we need to look at, you put this plans together. Did you do a traffic study? Did you do other studies to verify that this is the best place to put affordable housing? So my question is really from Mr. Salvo, and I would like to see this designated in separate wards.
The mapping is color coded so that you'd be able to, and numbered so that you could distinguish between the different densities. Quickly, density is not people, it's units. The way the COA regulations and obligation is calculated, it's the number of housing units. And in terms of traffic and other considerations, those are not concerns of the court. The obligation is, and then you get the traffic with it, and that's part of the problem with the process. So no, we did not do a traffic study because it would have been ignored by the court and it would have cost the city a tremendous amount of money. Now, having said that, that doesn't mean going forward as a concern, as part of the reexamination and master planning that goes on, that's not something that the city can investigate. But for purposes of this process, courts, you get the traffic with the obligation because it's constitutional.
Okay. Next in queue is Mr. Frank Huddle. Please unmute. Mr. Huddle.
Good evening. Welcome, everyone. For the record, I will submit what I said last night to the council. I will try to go quick. I strongly object to 3 minutes. And this process tonight and what has occurred today is anything but open and transparent government. The 4,000 units that Council President Marin questioned last night and Councilman Rosenzweig brought up, everybody is now aware, including those 2 council members, that is you, Mr. Sabo, that testified or reported on the record to the court on January 10th that the units are 4,000. That's step 1. Step 2, history.
I don't recall that, but okay.
Please don't interrupt, because it's been 2 hours now, and I've heard you and the attorney for the city report their arguments. This meeting was not to be about your support, why we should rush into something, but it should be about the planning issue raised or caused what we're standing here today. So now I just lost another 10 seconds. History dictates the future. 2009, Council President Rosenzweig, Mayor Wiles created a build a remedy suit. Everybody blamed the other, and that led into litigation. And this mayor and a team of professionals litigated and resolved it successfully. This city, Judy, Council President, to state that the consequences are so severe. The consequences that you're forcing a planning board to vote and breach your fiduciary duties is the responsibility of the governing body and potentially the mayor. This has started in 2019. There's no open process. As of November 2nd, the settlement agreement was submitted in court, e-court, public record. The council should have had a meeting the next day and explaining to the public. That did not occur. The agreement itself, the testimony is already pretty clear that it's a done deal. So why are you rushing these meetings, which are somewhat, I believe, an exercise of futility? To suggest, whoever suggested that this is open and the public are going to be able to speak, you're suddenly going to send notices to, I don't know, how many people, Mr. Are you going to send notices to? I won't give up any more of my time. I'm sure there potentially thousands that are going to have to figure out to get the notice and have a hearing rush in 25 days. That's not good government. What should be discussed here tonight is the ramifications of 4,000 units, 8 to 10,000 people, an increase in population, what it means to our schools, what's it mean to our police department. And trust, I will do this all in writing because I now understand as a resident, it's falling on deaf ears, but I have confidence in some of the council members and the planning board that this matter will be handled correctly and fairly. But fairly is not jamming it down the throats of our residents. 3 meetings. Could you see this? I don't know if I'm on the screen. 3 meetings, Tuesday, Monday to Tuesday, what is this now, Thursday, and then a public meeting. And we still don't have any documents posted. We don't have am I off now?
No, you're still on, Mr. Huddle. If you could just please wrap it up.
There was a question by a couple planning board members. We don't even have the detailed support. I am formally requesting the studies, the traffic, everything that goes into a site plan is not here. And Mr. Mayor, Evo was not under my administration. It was subsequent to leaving office. And that's a good example of what we should not have, cinder block on our streets in New Jersey. So, Council President Marin, yes, I'm pretty focused on this because the process is broken. But I do believe, and I have confidence in certain council members that they realize now this is not about the affordable housing. Whatever it is, and we could accomplish it very differently.
Thank
This
you,
is
Mayor.
about
Thank
our
you.
city and not gutting the master plan.
Thank you, Mayor.
Minutes, and I thank you very much for the 3 minutes.
Thank you.
If I may, Mr. Chairman and Council President, I think it's very important. A gentleman who served our city for 9 years spends 2 hours listening and is passionate about this. We didn't have a council liaison for a full year last year. And I realized that there is a timeline that is showing less than transparency. And my whole presentation and questions is about the transparency of the process. If there are members of the public that are distinguished or civilians who haven't served the city but are going to get mailings, I think it is the smart approach for us to study the master plan and the documentation and to have everybody assured at some point of transparency of process and the information and the content. And Mr. Huddle, you'll forgive me, I do not have a vote. It is not the responsibility of the mayor, and you know well about the charter of the city when it comes to making these decisions of litigation. But when it comes to the planning board, I do have a role in the pace of things going. And I agree with Mr. Cobb fundamentally. This process started a while ago, but it was only recently that the planning board was tasked to look at this, and it was jammed down at a speed that is not something that somebody can consume. So I agree with our former mayor, my successor and my predecessor. And I think it wise for us to spend the time, even if we have to go to a federal judge and tell the judge we need a little more time so that we can absorb this, because we are part of the process. We're not a rubber stamp. We have to look at this thing organically. Is it in concert with the master plan that we have? And if our master plan is dated because the last one didn't include flooding or other issues, we need time to do this authentically and more thoroughly. It's all about process. We are a city that will, God willing, make wise decisions in the future. We don't have to have even a federal judge put us to task if we're not up to it. And if good citizens are volunteering and former elected officials are spending hours at night genuinely inclined about this stuff, we ought to take pause.
Mayor, I'm sorry to interject with the utmost respect. This is a public comment period. We have to make sure that everyone has the time to make their comments and not to engage in back and forth.
Well,
say
then
that
give
with
people more
utmost
time if
respect
they
to-
let them
to
speak
both
for a second
the-
time, then Levi. Yeah,
Yeah, the
I
current and
appreciate-
former mayors, I say with the utmost respect, I just want to make sure everyone has a time to talk.
All right, thank you.
Next person in queue is Diane Jansen. Please unmute. Jansen?
There you go.
Yes, hello, Diane Jansen, Ridgeland Terrace. I have COVID, but it's important enough, and I have COVID, rebound COVID, and I'm sick. But this is important enough for me to attend. And I want to say a few things. I cannot say them in 3 minutes because I am sick. And even if I weren't sick, I couldn't say them in 3 minutes. But Judge Farrington will be able to hear what I have to say on August 23rd, because I have, along with my husband, put in negative comments about this whole plan and our concerns. And let me start by saying she will give us more than 3 minutes, and she has, and she will. First point, I am professionally a strategic planner. I've worked for CEOs of multi-million-dollar companies. And every CEO knows you put it on paper and it happens. This is in essence a new master plan without public input, period. On November 1st, 2022, the council mentioned a resolution authorizing a settlement agreement with the Fair Share Housing Center of New Jersey. I wanted to see a copy of that, so I opened it on 11/3. I never got a response back. I wanted to see that and any related documents. Later in November, I happened to come across on the city website the Englewood Fair Share Housing Center Affordable Housing Agreement and a notice that I could object to it if I wanted. My husband and I found this out so late that we had to have a letter. We found out on December 5th of 2022 that we had to hand deliver a letter to Judge Farrington's office in order to be able to object or provide our comments. And that is just the beginning. There's been plenty of time. This is not transparent. Excuse me to all those council members who say it is. We stumbled on this. And I was discouraged after we were sending in our comments, discouraged from requesting that we participate in the meeting with the judge. And I'm livid. I'm livid. And you know, the CEOs I worked for, they were not afraid of lawsuits, because when you're in the right and you're doing the right thing, you're not afraid. Let's stop this BS and go before the judge. And this is not my understanding, with all due respect, Ms. Gallo, this is a conditional approval. It's not a final approval. So you keep saying it's been approved like it's fait accompli. We can blow this up, and maybe we should. Thank you.
Okay, next to speak is Peter Jansen. Please unmute.
Good evening, Council and Planning Board. Pete Jansen, Ridgeland Terrace. In that November 2nd, 2022 settlement document, there was a table. It was an overlay zone table that listed every lot in every block that was within the overlay zone. If you were to look at those lots, there were a total of 359 lots in the overlay zone. And I went and looked, and I got concerned because I looked at how many of them were in the FEMA flood zone. And to equate it, I equated it to the number of units in a flood zone, because ultimately the impact is not in how many lots are in flood zone, but how many people who live in units that are subject to flooding that we are proposing as a city. And I found in those 359 lots, I found 131 acres total and approximately 3,500 units total. Of those 3,500 units, over 1,000 are in flood zones. Now that's a discrepancy from what our city planner just told us. And there's at least two reasons for discrepancies. One being, I'm talking number of units, and there's a different applied density. It could be 15, 35, or 50. And also it could be a difference in the flood resource map that is used. I use the New Jersey DEP flood map, which is based on FEMA 1999 data. Mr. Szabo could have used a different flood resource, but in any case, there's still a lot of units in flood zones. And where are those units by ward? I looked at it by ward, each of the 359 lots by their address and by their ward. I found over 60% in Ward 1. I found 34% in the 4th ward. That only leaves 6%. So the 3rd ward has 5% and the 2nd ward only has 1% of the total units. So while they are distributed to every ward, they are by no means evenly distributed by ward. And I would also add that in the January 2023 hearing, our city planner did cite, when I asked the question, our city planner cited the total potential as being approximately 160 acres and 4,000 units. So these are my findings based on looking at it by lot, by block. It clearly shows that the flooding is higher when you look at the units affected. And we really need to look at this in more detail, especially those lots in the 4th ward in the map IDs, the locations 5, 9, and 10. And those are the areas around William Street, West Englewood, next to the McKay Ice Rink, and down that corridor of William Street. Some notable lots that were selected: Walgreens, Bergen Family Center, Field Club, St. Paul's Church, the City Library, and the municipal complex was selected in the overlay zone. Our courthouse, police station, and firehouse. That's all. Thank you.
Next to speak is Laura. Please unmute.
I'm here. Can you hear me, Yancy?
Yes.
Okay, thank you. I'm a Ward 3 resident, and I'm looking at the affordable housing overlays, and I see two types of property that are slated here. And that is one is residential. The other is commercial. That commercial area shared by Ward 1 and Ward 3, that's the only commercial area here on Hudson Avenue. That includes our only pharmacy. That includes our takeout restaurants, our bagel shop, the hair, that famous hair cutting place. We've already lost our only bank in the 3rd Ward. These are things that should be considered for quality of life for here in us in the 3rd Ward. I don't need to go downtown to Palisade Avenue when I want a bagel. And my guess is those commercial properties there, those restaurants, those stores do not own those buildings. And actually, it's one large, long building on Hudson Avenue. My guess is the right price, perhaps the owner of the building will let it go. And there are also happen to be apartments above those commercial areas. So I would like to hear, especially perhaps my 3rd Ward Council woman or anybody else who'd like to talk about that. When you have commercial areas that are important to the residents, plotted out here for the affordable care. It's a huge area right there. It's the whole commercial section right there. So thank you.
I'm sorry, Laura, are you done? Laura?
Yes, I thank you. Thank you, Yancy. And I
Okay.
was hoping somebody might comment on that.
Yeah, I'll just quickly comment on this. Next Thursday, we have a prospective council meeting, which will be a great opportunity to bring these questions up. And this is just a public comment, not a Q&A time. Thank you.
No one else has their hand raised.
All right, at that time, if no one else has their hand raised, I'd ask the clerk to seek a motion to close public session for the governing body.
Sorry, I didn't hear you, Levi.
A motion to close the public session for the governing body.
Close public session. I'm gonna have a motion to close public session.
Could we have a motion, please?
I'll make a motion.
Second?
I'll second it.
Okay, Yancy, roll call.
And then we need the same from the planning board.
So moved.
So second.
Again,
All right, and then I think that concludes our meeting. I appreciate everyone's attendance tonight. Thank you all. Thank you to our professionals for showing up. And have a great night, everyone.
I think we need to vote. We need to vote on those motions.
Need a motion to adjourn.
Oh, sorry. Yeah.
Yancy,
Just an all
roll
in
call.
favor. It's just an all in favor. Say aye.
Aye. Aye.
There's
thank you,
no-
John.
there's
Thank you,
no-
Kelly.
Now we
There's
need a
no
motion to adjourn.
conflict in the meetings. Is there, Levi, the council meetings and the planning board? There's no double duplicity in meetings the same night, correct?
Board of
No, as long
Adjustment
as they
is,
vote on their separate resolutions and their separate approvals, they're fine.
Right, the Board of Adjustment does have a conflict though with one of them, but it shouldn't interfere with.
right, I thought you were referring to the 28th, but never mind.
Yeah, no,
It's
but I
talking
just
about-
want to make sure we're not scheduling things at the same time because I want to participate in both.
Yep.
Okay. All right, thank you, everybody. for
All right, good night,
professional-
Thank you. Thank you.
Thank
Good night.
you.
All right, thank you.
Good night.
Bye.
Bye.
Yancy,
Yep.
1 second. Is there a link to the closed session?
So the what session? We're not having a closed session.
Oh, okay. I thought that was the motion.
No, that was a motion to close the public
To
hearing.
close the meeting. Okay.
Yes, yes.
All right. Good night.
Good night. See you tomorrow.
All right.